application by Hugh Jordan for judicial review.
Please, my ladies, my lords, I appear for the appellant in this matter with Ms Doherty, instructed by Madden and Finucane solicitors. Dr McGleenan appears with Mr Coolmer for the second respondent, instructed by the Crown Solicitor's Office. Mr Call appears with Mr McAteer, for the, instructed by the Department Solicitor's Office for the third respondent. And you should also have a written submission from the first respondent, who are represented by Mr Dorn and Mr Skelt.
We do, but they have agreed that they don't need to be here.
That's correct, my
Yes.
lady. My ladies, my lords, this is an appeal from the decision of the Court of Appeal handed down on the 22nd of September 2015 relating to proceedings concerning the appellant's claim for damages for breach of her Article 2 rights by virtue of the delay in the conduct of the inquest into her son's death. The Court of Appeal ruled that proceedings in which an applicant sought to challenge the delay in the conduct of an inquest and sought damages under the Human Rights Act by virtue of that delay ought not be dealt with until the inquest has concluded, and it is this decision that's challenged. Significantly, the Court went on to state that, and the reference can be found at MS 185 of paragraph 22, but I don't think I need to take you there at this stage. The Court went on to state that we find it difficult to envisage any circumstances in which there should be an exception to that approach. We say that the Court of Appeal clearly laid down an approach to challenges such as that of the applicants of general application, and it is that which we say makes this a point of law of more general importance. My ladies, my lords, we find ourselves in a somewhat curious position in presenting this appeal, in that the legal principles that we have contended for, which we have outlined in the appellant's case in support of our submission to the Court of Appeal, was in error, are principles which the respondent in large part accepts, and I can take you to the relevant parts of the appellant's case in short form if that assists. But essentially we say that the respondents in large part accept our outline of the legal principles which govern the case. The distinction they make is, and the case that they advance is that the case is that we have misunderstood the judgment of the court. We have mistakenly attributed to the court a rigid legal principle, failing to appreciate the flexibility of the judgment, and we have mischaracterised what is an innocuous case management decision as a denial of the rights of victims of investigative delay to access to the courts to secure the protection and vindication of their Article 2 rights. And with respect to the position of the respondents, our case in short form is that the Court of Appeal, in arriving at its decision, did formulate an inflexible approach, one from which, in their own words, they could not envisage any circumstances which would justify an exception to such approach. And fundamentally, we say that approach conflicts with a clear and consistent line of Strasbourg authority, which they ought to have taken into account, but didn't, and which they have given no good reason for their departure from that line of authority. Lords and ladies, just to summarise the outline of what we say is the clear and consistent line of Strasbourg authority.
Is it consistent, Ms Quinlivan, or is it constant? I thought the word used by Strasbourg was normally constant.
I have to say, you may well be right. I have always used the term consistent, and I probably read that.
Well, I may or may not be right, but it's been troubling me for some time.
Well,
if it's constant but inconsistent, we might think twice before following it. So
yes, I had thought it was consistent, but I'm not.
I know consistent makes much more sense than constant, but nevertheless,
maybe that's why that's why it attracts me. In any event,
let's be clear. You say that their interpretation is different from yours.
Yes.
And if their interpretation is the right one, would we be here?
Well, obviously the court granted leave, so the court at least was persuaded by our petition that this was a point of more general, the court granting leave was a point of more general import. But we say the reality of the situation is that, well, firstly, two things.
I mean, sorry, I'm really just wondering. I mean, if he hadn't included the word, he can envisage no exceptions. it'd be difficult to quarrel with the judgment, wouldn't it?
If it had been narrowly confined to this case and it didn't impact on other cases, yes, I imagine we would have had significant difficulty in persuading this court to grant leave. And we did in our submissions at leave, and subsequently we obviously have emphasised not just the impact on this appellant, but more generally really on those who are adversely impacted by inquest delay in Northern Ireland.
Yes.
And you have the annex from the third respondent in that respect. In our case, I don't propose to read the case to your lordships and your ladyships, but perhaps just to refer to our submissions and to the response from the respondents. We essentially, I don't think anyone is disputing the general principle of what Section 2 means in terms of the obligation to take cases into account, and the general approach that is taken, which normally the court won't depart from a clear and, I'm going to go with, consistent line of Strasbourg jurisprudence. But we have gone on then in our case at MS 109 through to 110, and I don't intend to read it out, but we set out what we say Strasbourg jurisprudence establishes in terms of Article 2, and your lordships and ladyships will be familiar with the obligation to conduct an effective official investigation. That one of the minimum criteria in terms of an investigation being effective is that it be conducted promptly and with reasonable expedition, that the family of a deceased person can establish a breach if there's a failure to comply with the minimum requirements, and most significantly in terms of the case law, in order to establish a breach, it's not necessary to await the conclusion of the investigative process. It is simply sufficient to establish that in a particular case, at the time the decision is made, there hasn't been, the proceedings haven't issued promptly and with reasonable expedition. And that point, we say, is illustrated very clearly, both in the decision in the Jordan case itself, which was initiated before the inquest. If that was an outlier, because certainly in the first four cases were taken, I think Jordan was unique in that the inquest hadn't concluded. In the other cases, the inquest had either been terminated, although not heard, and concluded. But we've had the more recent decision of McShane, where again the inquest hadn't concluded. And of course, the court has, in the cases, and I can take your lordships and ladyships to them, but in the cases of Hemsworth, McCaughey and O'Donnell, those were all cases received by the court at a time when the inquest hadn't concluded. So we say that there's no suggestion from the Strasbourg courts that you can't challenge the Article 2 investigative obligation as ineffective on the basis of a breach of the promptitude requirement, that you have to wait until the conclusion of the case. Yes.
Isn't your complaint really that your claim is not being heard within what you would say was a reasonable time?
Yes, but also I suppose we complain more generally of the impact on other cases and the inability of other applicants to advance their case.
Whichever way you put it, so framed, it falls more naturally under Article 6, not Article 2.
Well, except that I see where you're coming from in terms of access to the court. I think except that the protection, I suppose, of access to the court in terms of the applicant's ability to promote their Article 2 rights is protected under the remedial structure of the Human Rights Act, Section 6 and Section 7. And what we say is, in essence, that we are denied the ability to gain access to the court to do that. I should acknowledge, in case it isn't clear from the papers, I think it probably is at this stage, that of course the Court of Appeal has now heard the appeal. So the appellant in this case has been heard on the issues. The appeal and the cross appeal have been heard. We're awaiting judgment in relation to the cross appeal and the issue of damages. But that remains. So I have to.
So what's the exact position in relation to your judicial review?
The position is both the appeal and cross appeal have been heard. The cross appeal, which was to suggest that the coroners had responsibility for delay, has been dismissed. So the only issue really before the Court of Appeal, which has yet to be determined, relates to the Police Service of Northern Ireland's appeal, which is they don't complain of the declaration that there was a violation of Article 2, but they complain that an award of damages should not have been made against them on the facts of this case. And it is that decision that we await the outcome of. And I should also, just because the court may not be aware, the court will have seen in the papers that the appellant had challenged the verdict in the inquest. Leave had been refused in the High Court. Leave was refused in the Court of Appeal, I think last week or maybe the week before, but just within a very short period. So we would have arrived at any stage, at this stage, at a point at which the Court of Appeal would have been prepared to hear the appeal. But of course, ironically, that has passed. But that's the up-to-date position.
So the challenge to the actual inquest verdict, that is now dead, is it?
Yes.
Ms. Quinlivan, returning to the Court of Appeal preliminary ruling, is it limited to a claim for damages itself, or does it extend to any more general challenge based on delay in the proceedings?
It isn't of it isn't of totally general. Or, that there have been challenges taken, and the courts have permitted challenges. So there have been, I think, 2 challenges taken to inquest delay, and that is challenges to the Department of Justice, the Secretary of State, and the overarching public authorities complaining that they, I think the former First Minister, and the complaint in that case, it's in your Lordship's bundle, I think it's tab 2B, tab 23, it's case of Hughes, but in any event, the Jordan judgment did not preclude that challenge taking place, and that was a challenge to the failure to secure funds from Westminster in order to provide greater funding for the coroner service and enable the backlog essentially to be dealt with.
That was more specific than a claim based on the simple fact of delay.
Yes, yes. So that claim wasn't precluded. I think, I have to say, when I was reading the judgment again yesterday, it may be arguable that the judgment may be of slightly wider import, in the sense that, on one view, it is arguable that what has been suggested is that if I was to make a complaint about, sorry, if I just get the judgment.
At paragraph 20, for example, the point is made that declaratory relief or mandamus may be enough to secure the right. What's not clear to me at the moment is whether the effect of the ruling of the Court of Appeal would be to prohibit an application made on grounds of delay for declaratory relief or mandamus.
My understanding is that is the impact of the judgment, because
it would.
It would preclude declaratory relief and it would preclude mandamus effectively. So it closes down any avenue, and that, of course, is one of the particular difficulties, because while a claim for damages, it may well be something that the applicant will want and will benefit from. There have been claims, for example, in the domestic courts, where applicants, for particular reasons, don't wish to claim damages, but nonetheless, what they do want is for the courts to say, your inquest must proceed, and you must take all reasonable steps to do it. And that is also foreclosed by this judgment, which obviously, therefore, Article 2 as a mechanism for advancing inquests is really closed at the moment, we say, in terms of Article 2, and that is a significant... Sorry, and just... if your lordships want the Hughes judgment, and I'm not proposing to open it certainly at the moment, but it's in bundle 2B at tab 23.
Thank you.
And you'll see a case about delay that is dealt with by the courts and which isn't adversely impacted by this judgment.
Can you just confirm that the copy of the judgment of the Court of Appeal that we have is the revised version that was issued in 2017?
Yes, yes. My lords, my ladies, I had been going to just identify what are the slight differences in approach on the part of the respondents. And if one goes to the case of the second respondent at MS 134, 134 simply there's an indication at paragraph 29 that there's no issue that the death in this case, the inquest into the death in this case has been the subject of delay, and there's no disagreement that domestic courts are not obliged to follow Strasbourg jurisprudence that normally do so. And they don't disagree in principle with our description of the adjectival rights and obligations which are said to flow, but there is some caveat entered really at paragraphs 32 through to 34, where it's suggested that we fail to highlight the fact that the Strasbourg court, when assessing whether the procedural obligations arising from Article 2 have been appropriately discharged by a member state, the Strasbourg court invariably considers the proceedings as a whole, and your lordships and ladyships will have the reference that my friends are directing you to. And they go on at paragraph 33 to say that in our case it's stated it's not necessary to wait the conclusion of the investigation before bringing proceedings in order to allege a breach of Article 2 investigative delay, and that the second respondent doesn't disagree with this proposition. And they, at 34, they acknowledge the line of authorities that we've referred to and that I've referred you to orally. And then the caveat really is that there is no Strasbourg jurisprudence which has criticised a domestic court for electing to assess the proceedings as a whole before making a determined and just satisfaction. And our response to that particular caveat is a short one, and that is that there has been no such case brought to the Strasbourg court. The court has never had to address the issue. This would inevitably, arguably, be the case in which it would have to address the issue if that was to occur. But the court faced, in any case, with delay sufficient to merit its disapproval as the case not having advanced promptly and with reasonable expedition, has found a violation, and it hasn't made any artificial distinction between the point at which the court is dealing with. The court looks, it does look, as my friends have said at paragraph 32, it does consider the proceedings as a whole as they are at the stage at which they arrive before the court. The third respondent's position might be, and no doubt this might be argued to be slightly more robust, and you'll find their dealings with this particular aspect of the case at MS 152, paragraphs 44 and 45.
Paragraph?
Sorry, it's MS 152, paragraph 44 and 45. And it states, in order to make an award of damages, all the circumstances of the case must be taken into account. All circumstances can only properly be ascertained once the delay has crystallised and the inquest is complete. We agree with the former part of the sentence in the sense that the circumstances can be ascertained once delay has crystallised, but it's not necessary in our view to wait the completion of the inquest.
But isn't it important to see what weight the coroner has given to certain events that occurred in the course of the inquest? Certain evidence.
I see the force in your ladyship's submission, but you do see, when looking at the judgments of the European Court, that they make adverse findings about delay without the necessity to demonstrate that it has a particular adverse impact. It's assumed, I think, that once you have delay and arguably it's on one view, it's self-evident that certainly if you have delay of 10 years before an inquest is heard, it's going to have the potentially adverse impact in terms of memories. But the European Court hasn't thought it necessary to say, you have demonstrated, and I'm conscious of this because we, particularly in the Hemsworth case, we did argue that there were particular difficulties about how the inquest was conducted because of delay. There were witnesses who had disappeared and documents which had been destroyed, but that didn't create any additional, as it were, adverse comment by the court. They seem to approach it from the point of view that delay undermines public confidence in the rule of law. They adopt that as a principle and make adverse findings accordingly. I can see the force, obviously, in if you're talking about a delay in a quantum of 4 years, the idea of bringing a complaint every 2 years because you're dissatisfied about delay, there's a certain force in the argument if delay was not endemic in the kind of lengths that we're talking about in Northern Ireland. Because to say, as the court has in cases where, and one of the cases that we will refer you to, in cases where the deaths occurred in 1992 and 1997, where leave is given to judicial review, and then those cases are stopped because of this judgment. To say that you can't make a finding that there hasn't been adverse delay, really, in my respectful submission, it is self-evident that if you haven't had an inquest from 1992 through to 2017, there is only one conclusion, in that there has been delay and a breach of the promptness requirement.
Suppose the respondents want to say, well, a lot of the difficulty was about researching the ballistics evidence and finding all the facts necessary for the expert to give their opinion and so on. And the coroner may decide that that evidence is of no value at all, but he may, on the other hand, decide it's critical. Would that be relevant to the assessment of damages?
Well, the other issue about damages, and this appears from the High Court judgment, is that the Strasbourg court has adopted an approach of giving what appears to be a standard sum of damages regardless of the quantum of delay. So you'll see, for example, and it might be useful, well, in the Jordan series of cases, you had different periods of delay. So in Jordan, you had a period of delay of 9 years. You had other violations as well, and you had a quantum of £10,000. In the Shanahan case, you're talking about a delay of approximately 4 years in the hearing of the inquest. And the inquest in that case had been heard. The same quantum was paid. When you look at the cases of Hemsworth and McDonnell, you're dealing with different lengths of delay, but the same quantum. So Strasbourg really seems to adopt an approach of saying, if there's delay, there's breach of this obligation, we will pay damages. But if you come before us with 20 years delay, or 10 years delay, or 5 years delay, we're not going to engage in a process of varying the quantum accordingly.
But I mean, where does that leave the domestic court? I mean, whereas Strasbourg deals with the case that comes before it, and it's not having to sort of case manage a whole lot of cases as Lord Chief Justice is in Northern Ireland. And so no doubt it takes a fairly sort of standardised approach to this question. But are you saying that the domestic court has to adopt the same approach?
Well, the domestic courts, in terms of how they deal with damages cases, have normally adopted the approach that we look at what principles Strasbourg applies in terms of damages.
Well, they're required to, aren't they, by state?
Section 8 requires it, yes.
Yes.
But the question is what they do with them.
Yes.
And there's nothing which says that they've got, at least in fact, that regardless of the length of the delay and the circumstances, they give the same sum.
Well,
is that?
And I mean, I can see the force in the argument that there should be greater sums awarded for lengthier cases, and applying the kind of approach that we would take domestically, I envisage that would be the approach. But Strasbourg hasn't adopted that approach. It has adopted a very blanket approach of saying we really make the same awards of damages regardless of the fact you come before us with 4 years delay or 10 years delay or even 20 years delay. And given that approach, that appears to be essentially the obligation on the domestic courts to apply that approach.
But the Strasbourg judicial process is different. It doesn't have a fact-finding process as the domestic court would do. There are no pleadings on damages. There are no filing of evidence.
No, but this case was adjudicated upon as a judicial review, where the parties put out their submissions in terms of the delay that had occurred and what the reasons for it on paper. And the additional benefit the domestic court has is the hear oral argument. But the Strasbourg court, essentially, when it's dealing with complaints about delay, asks the applicant to set out the reasons for delay, the periods of delay, the reasons for delay, and the government responds with whatever explanation.
But if there's a dispute about the causes of delay, Strasbourg won't deal with that. They will simply make an assessment without deciding the points in dispute.
Well, I'm not sure that's entirely right, in the sense that if you look, and perhaps it's worth looking at the judgment, the Strasbourg judgments, I suppose the three discrete judgments where delay was the only issue. You find them at Volume 1, Tab 6, in sequences is the case of Collette and Michael Hemsworth. And
Sorry, what's the reference?
sorry, it's Authorities Volume 1, Tab 6, and I'm looking at MS 843. And just there had been a number of complaints of other aspects of the investigation that had been brought by the victims, but the court took the approach that, and you'll find this at paragraphs 67 and 68. It says, in all of the above circumstances, the complaints under Article 2, other than the complaint about investigative delay of itself, are inadmissible as being premature and or on the ground that domestic remedies have not yet been exhausted within the meaning of Article 35(1, and the associated complaint under Article 13 must also be rejected. And the court goes on to say, it notes that should the applicants be dissatisfied in the future with the progress or outcomes of those domestic procedures, it would be open to them to reintroduce those complaints under the substantive and procedural aspects of Article 2. However, the consequence of the referral of the case to the DPP, because, and this is in the context where at this stage the inquest had concluded and the coroner had referred the case to the DPP, with the potential that entails for further proceedings of a criminal and or disciplinary nature, is that the investigative process into the death of Mr. Hemsworth is still not finished 15 years later. The court considers that the complaint under Article 2 about investigative delay is not manifestly ill-founded and is declared admissible, and then it goes on to deal with the merits of the case. And it outlines the general principle at 69. Article 2 requires an investigation to begin promptly and to proceed with reasonable expedition, and it refers to the judgments in Jordan and others. And this is required quite apart from any question of whether the delay actually impacted on the effectiveness of the investigation. So I think, my lady, that is what we say in response to your question, that they do look at delay regardless of whether it impacts on effectiveness. They might also find that a delay of 20 years meant that all the relevant witnesses were deceased.
And in paragraph 71, they're clearly looking at the reasons for the delay
yes.
and finding that they're not justified.
So they're examining
Really
what the government says and being critical. Yes, my lady. So firstly, they just deal with the quantum of delay, paragraph 70. And then they note during this period there were a number of delays which the court considers attributable to the authorities and which are not justified. And they go on to effectively analyse the periods of delay. The Attorney General had directed the inquest into this case, and they criticised the 16-month period between the Attorney General communicating the need for an inquest and the first preliminary hearing, and note that greater speed should have been imposed given the initial mistaken registration of the death. They then note the adjournments that took place really subsequent to the European Court's judgments of May 2001, and the issues in that weren't ultimately resolved until the series of cases before the House of Lords, culminating in Jordan and McCaughey in 2007, and they then criticise the further delays. So the court does examine, I accept in broad brush terms, but I think Mr. Justice Stevens, when examining delay on the part of the PSNI, also took a relatively broad brush approach. He said he wasn't going to delve into the minutiae of every dispute and argument, but he identified periods of delay where he felt the PSNI were culpable. But we say that two factors emerge, and one is that delay may well impact adversely on the effectiveness of the investigation, but it seems to me that reading the judgment that would probably also result in a finding that the investigation had been ineffective. So you would have a breach of the delay requirement, but also a breach of the effectiveness requirement. If that was the conclusion.
Ms. McQuillan, if I could just ask you to pause for a moment. I'm having difficulty with lack of a structure here. If we try to think about things, there's a statutory right to bring a claim where a person contends that there's been a violation of their convention rights. Right. Section 7.
Yes.
So a court cannot stop you from bringing a claim
Yes.
bound by the statute.
Yes.
On a claim, the court can grant any relief that it considers appropriate in terms of Section 8. And that can include an award of damages.
Yes.
So if we're thinking simply about what rights you have of access to a court for the moment, is there any legal basis for saying that a person is not entitled to bring a claim before the court for a breach of convention rights, and including in that claim an application for relief in the form of damages?
My lords, there's no legal basis, we say, on which a court can do that, but we say the impact of a Court of Appeal judgment in real terms is that for those applicants who came before the court who had leave, their proceedings were stopped.
Yes, I see that might be the how it could be read, and indeed the order the court made on page 177 is that the claim for damages should not be brought
Yes.
until the inquest has finally been determined.
Yes.
So if there's a statutory right to bring the claim, then I suppose the issue is whether the court can decline to deal with the claim for damages until after an inquest has concluded by adjourning that aspect of the claim, for example.
Yes. Well,
I think at the end of the judgment, the court said it wanted to hear parties on whether it should adjourn that part of the appeal, or whether it should simply a fresh claim ought to be brought at that stage. But there seems to be a debate about whether, if the court says we're not going to deal with your claim for damages now, we're going to deal with it after the inquest, whether that's to be categorized as an issue of case management, or if it falls outside the scope of case management.
Well, I think our central submission is that it falls outside the scope of case management because of its impact on the applicant's ability to pursue her statutory entitlement to bring the claim, and also because of the impact of this judgment on the right of other applicants to pursue their statutory entitlement. And I should indicate that in another case, which has been stayed as a result of these proceedings, the indication was given by the then Judicial Review judge that leave would be refused in these cases if they came before the court, in light of the judgment. And one can understand how the High Court would be influenced by the, we say, very strict terms of the judgment, that the court couldn't envisage any circumstances so exceptional as to justify departure from that general approach. But the effect, we have said, is one, there's the rejection of the line of Strasbourg authority, but secondly, it undermines the remedial structure of the Human Rights Act. It effectively precludes people from accessing their rights. It doesn't do so by saying you don't have a right to bring a claim, but the import of it, coming from a court of appeal, is to the same effect. And if I could make two observations about what the Court of Appeal says in that respect. Firstly, it does have the influence it does, but secondly, what the Court of Appeal has done, well, I suppose one issue is, if my friends suggest, look, they still acknowledge that there can be exceptions, that there may be some exceptional case that would meet the favour of the court, so it's not a blanket rule. And we say, firstly, if the case of this applicant, who had already been to Strasbourg, successfully established a violation of his Article 2 rights in 2001, and yet it takes a further 11 years before the inquest into his death starts. If that case is not exceptional, it's difficult to envisage what cases will be exceptional if that case doesn't fall out within the general circumstances. But secondly, and more fundamentally, on what legal or jurisprudential basis can the Court of Appeal impose an additional hurdle?
Sorry, just before we come back to that, we seem to have left the Hemsworth case.
Yes, sorry.
And I was going to ask you before you do, where we find the principles by which the court assesses damages.
Yes.
Because I can't see any.
Sorry, my lord, I'll...
It's at page 846, we have the award.
There isn't, in these cases, necessarily any terribly detailed discussion on...
There's none at all, is there?
Sorry?
There's none at all.
No, although I draw your lordship's and ladyship's attention to its distinction between this case and the case of O'Donnell, which illustrates the point I'm making about the court giving the same amount of damages regardless of the circumstances.
Well, no, and what I'm looking for, what we have to do, what we have to do under the statute is to apply the principles which the Strasbourg court applies. So one's looking to see what the principles are. And I think I said in one case it's quite useful when they actually say they are applying principles.
Yes.
So if there's another case which tells us what the principles are, let's look at it.
My lord...
In the case which Lord Conroth is referring to, I think we also said that you might be driven to have to infer the principles from the practice.
Well, that's, I think, where I was
But if
going.
there's a principle that you give the same amount, regardless of whether the delay is 4 years, 10 years, 20 years, that does seem a surprising principle.
My lord,
I'd like to see some authority.
that isn't overtly stated anywhere. And we derive our understanding of that position from, firstly, if you take the first 4 cases that are brought together, the Kelly and others case, McCare, Shanahan and Jordan, all of which involve different periods of delay, but all of which end up...
It can't be the case that if you exercise your right under Section 7 to bring a case every 5 years, the delay, you get your 20,000 for each 5 years, whereas if you don't exercise your right for 10 years, then you only get...
I understand.
Now, I don't believe that's a principle which the domestic courts have to apply unless it's clearly set out in some Strasbourg judgment.
Well, my lord, I can take you to the passages and which deal with the issue of damages. I can't point out to you and say there's a statement of principle in the manner in which we would understand it, clearly articulated, but we say that there are inferences to be drawn from the manner in which the court has approached it.
I suppose, Mr. Quinlan, whether you go to Strasbourg or you bring your claim in a domestic court, you are seeking to establish that there has been a violation of your Article 2 right.
Yes.
And if you establish that, the court then has to consider whether an award of damages is or a monetary award in Strasbourg is necessary in order to afford just satisfaction for the violation.
Yes.
And if in the case of Jordan itself, the applicant went to Strasbourg after a delay of however many years, 9 years you said it was, and a violation was found, and a monetary award was made under Article 50 or Article 41, whenever it was, as just satisfaction. If another 10 years then passed during which there was still no inquest, and there was a further complaint of a further breach of the Article 2 right, the court would again consider whether a monetary award was necessary as just satisfaction for that violation.
Yes. I mean that is obviously the approach Mr. Justice Stevens took to this case. He did take into account, and he considered relevant, and we don't take issue with the fact that it is relevant in determining whether just satisfaction is necessary, to look at the fact that the applicant obtained just satisfaction from Strasbourg in 2001. And if the inquest had been heard in 2004, for example, while periods of delay of 3 years have been criticised in Strasbourg, one can nonetheless see that a court would take the view that you have just received relatively recently a payment of just satisfaction, and it's not appropriate to make a further award. I mean, Strasbourg hasn't ever directly faced the scenario that we're discussing. In other words, an applicant coming back after a further period of delay. That hasn't happened to date. And I'm trying to, I suppose, deal with Lord Cornwall's concern about the lack of principle. The paragraph I was going to draw your attention to, and just to contrast it then with a subsequent paragraph in relation to the O'Donnell case, you'll see it's at 79. The applicants requested an award in respect of non-pecuniary damages.
Sorry, where are you?
Sorry, I apologise. I'm at the Hemsworth judgment.
Volume 846.
Yes, sorry. I apologise. We've been...
Well, there isn't a statement in Hemsworth as to what the principle is.
No.
It just
No, it doesn't, and I'm seeking to infer principles rather than, I'm not suggesting that there's a clear statement of principle.
But is there any statement of principle? You know, if there's a case which has a statement of principle, let's see it. But if, as I suspect, there aren't any, and they just give awards, then we've got to do the best we can with that.
Yes. There is, though, a distinction between what's done in Hemsworth and O'Donnell, which I think invites an inference, which I'll invite the court to take, because you will note that in the case of Hemsworth, psychiatric reports were provided to the court, which underlined the adverse impact on them of the death of Mr. Hemsworth, and which in the case of Mrs. Hemsworth attested to the fact that inquest delay in particular was a significant factor in the persistence of her problems of depression and anxiety. And you'll see the court awarded the applicants €20,000, 10,000 to each applicant. Those are the awards which are essentially consistent with the awards which have been given in other cases. In McDonnell...
just before you leave the
yes, sorry.
Don't we have to read the awards with the observations, i.e. the cases that each party had put? And we see those by looking at the relevant passages in the observations. It's clear that the only issues were, well, there's a certain amount of common ground about it in this case. The issues were of a relatively systemic kind, not of the sort that I'm mentioning. The question about underlying facts arising out of this particular inquest, which could have meant that the inquest would necessarily take a long time and would be something that the respondents might want to deny. And just adding to that, i.e. that there are different types of issues, the factual issues that would we find any assistance in the jurisprudence under Article 6 about length of proceedings? Because then the court does look at the type of proceedings.
The court has, and I think we were going to refer you to an authority which isn't in the bundles, which takes a different approach to delay. The court will have regard to the complexity of the proceedings and whether there's any particular justification for delay. It's right to say that the court in this case was looking at systemic issues, but that really was over the period 2001 to 2007. But I think it is noteworthy in this case, at paragraph 71, MS 844, and I've drawn your attention to this already, that there's a discrete criticism of a 16-month period between the Attorney General communicating the need for an inquest and the first preliminary hearing, that 16-month period. So that's looking at, I suppose, the minutiae of the case as opposed to the general systemic issues. The court then goes on to deal with systemic issues thereafter. And then you'll see towards the end of that paragraph, so the systemic issues really take the government to the decision of the House of Lords and Jordan and McCaughey in 2007. And then the court observes it took a further year after that last judgment, March 2007, to hold a pre-inquest hearing. The delay between March 2008 and September 2009 was explained by the coroner's refusal, later overturned, to call RUC witnesses. There was further delay between the date initially fixed for the second inquest and the date it began. So they then go back to deal with the minutiae. But
there's no factual issue. I think the government accepted much of the delay. It was a question of whether it was attributable and justifiable. There wasn't, for instance, a challenge to the psychiatric evidence. It wouldn't have been. No, there wasn't. But there could have been. There could have been a challenge of a very deep nature.
But what I'm hoping to illustrate by reference to the O'Donnell case is that the reality is that the psychiatric reports made no difference, that in fact the court doesn't pay regard to the adverse impact on a particular applicant of delay, as was evidenced in the case of Mrs. Hemsworth.
What you're saying is that they've got a standard sum.
Yes.
A bit like bereavement damages.
That's a very good analogy.
Wrongful pregnancy damages. You know, it's a conventional sum which is awarded irrespective of the actual circumstances of the case. But my lady's point is slightly different, or a lot different, which has to do with the basis of liability.
Yes.
It's different.
I wonder, could I ask you to look at the case of McDonnell versus the United Kingdom, which you'll find at tab 8 of the same bundle. And the discussion about delay and the court's assessment of delay occurs at page 920, MS 921. Again, this was a case in which there had initially been other complaints before the court, but this case was decided after judgment had been handed down in McCaughey and after judgment had been handed down in Hemsworth. And it was apparent from those judgments that the court wasn't going to deal with other issues around effectiveness until the outright conclusion of the investigative process, and there were issues about disciplinary proceedings and criminal proceedings, and so those issues weren't pursued. The applicant's position on delay you can find outlined at MS 920 and paragraph 82, and it goes through the various periods of delay, and you'll see some of it is very specific to the case, some of it again deals with structural issues. So you'll have, at the outset you see the post-mortem was conducted on the 30th of March 1996, and the report wasn't forwarded to the coroner until April 97. No explanation has been given for that delay. So you do see scrutiny of the particular facts of the individual case, and thereafter discussion of the more endemic problems. The court's findings can be found at paragraph 88. They discuss the delay between March 1996 and April 2013. And they say there were a number of delays which the court considers attributable to the authorities and which are not justified. The decision of the DPP not to prosecute was not taken until over a year after the death of the applicant's son, even though the autopsy was carried out on the day of the Mr MacDonald's death, and the RUC had interviewed relevant witnesses in March and May. And you'll see again, they do look at the minutiae. So one can see if the government said there were particular difficulties with identifying witnesses, that might have been an issue. They observed that the applicant was not notified of the DPP decision until she made specific inquiries of her solicitor in 2002. It observes that following the decision of the DPP in May 1997 not to prosecute, an inquest hearing was set for a date 9 months later, and then the inquest was adjourned, and what follows are the systemic issues really which go through until the House of Lords judgment in Jordan and McCaughey in 2007. But they go on to note, thereafter further delays were encountered as a result of applications for anonymity made on behalf of the prison officer witnesses, a failure to disclose by the PSNI for which no explanation has been provided. There is no evidence in the documents before this court that steps were taken in recognition of the delay to date to expedite proceedings and resolve outstanding preliminary issues. In the event, full disclosure was not made until September 2011. Now, clearly the government could, had there been an explanation for these periods of delay, advance such explanation, which the court would no doubt have taken into account. At 89, they observe, as they have done in all of these cases, that between May 2001 and March 2008, on account of legal actions in other cases, there was essentially a systemic issue. And at 90, they go on to say, in conclusion, whatever the individual responsibility or lack of responsibility of those public officials involved in the investigation process, these delays cannot be regarded as compatible with the state's obligation under Article 2. The discussion on damages it occurs at MS 923, and it's not a lengthy discussion. At 95, the applicant claimed €10,000 in respect of non-pecuniary damage. In other words, the same sum as had been awarded to the two applicants in the case of Hemsworth. The government argued that unlike the applicants in Hemsworth cited above, the present applicant had not established any suffering and distress meriting an award of non-pecuniary damages. In particular, she had failed to provide any evidence or details in support of her claim. And the court went on, the court is satisfied that the applicant has undoubtedly suffered distress on account of the lengthy delay in the case. It awards the full amount, namely $10,000, in respect of non-pecuniary damage. So the contrast I make is simply this, that in Hemsworth, and I should say the psychiatric report was lodged in order to see whether more significant awards of damages could be made, but the court really doesn't appear to take those kinds of matters into account. And so the inference that we draw from the authorities is that really there is a standard amount payable.
Well, is there any authority in which damages have been awarded in Strasbourg which aren't €10,000 per person?
Well, the original awards were £10,000. In Shanahan, the award was £8,000. McShane, sorry, the award was £8,000.
Oh, it's £10,000, yes.
And this is discussed by Mr. Justice Stevens in his judgment, and he isn't able to identify a distinction. And I have to say, I'm not able to identify a distinction either. A different approach to damages was taken. I'm afraid this authority isn't before your lordships, your ladyships, but if you'd permit us to ask you to look at the case of Brecknell versus the United Kingdom.
Wait, sorry, Shanahan, just before,
Yes.
Before you lead, what was the reference to that?
McShane.
Oh, no, that's 10, is it? Yeah.
Sorry.
No, I mean the 8,000 award was in, you said Shanahan.
Yes. It's volume 1,
10.
tab 9.
You know, in the case of Sternum, also sometimes referred to as Faulkner, the court laid down, in the case of Sternum, sometimes referred to as Faulkner, the court laid down a procedure to be followed in cases of this kind. The parties are supposed to prepare a Scott schedule with a list of the relevant cases in Strasbourg, the amount awarded, and any observations that are relevant, for example, whether it was an award to one person or two persons or whatever it might be. And that greatly facilitates this court's job in trying to make sense of the Strasbourg case law.
Well, I'm sorry that we didn't perform that exercise, and no doubt it's something that we could, by agreement, perform for the assistance of the court after the conclusion of the case. But I can indicate to your lordships that there's a relatively discrete number of cases. You have the 4 cases in 2001 where sums of £10,000 were awarded. The court then seems to have switched at some point to euro. You have the case of McShane, which was heard subsequent to the other cases.
That's the 8,000 one.
And that's the 8,000, and you'll find the reference to that.
961.
Yes, MS 960 and over the page. And I can take you to Mr. Justice Stephen's discussion on it. He formed the view, and I really can't comment on whether that was correct or not, that the government in that case, you'll see at paragraph 155, made a distinction about the nature of the case. It disputed that any award of damages would be appropriate in the present case, in particular due to its character of a tragic accident. Even if a breach of the procedural obligation was found, it was far less serious than those found in the previous Northern Ireland cases, and the amount of damages should be significantly lower. So it would appear that there was some weight given to the government's representation that this case should in some way be distinguished from that of the earlier cases. And thereafter you have the cases of Hemsworth and McDonnell. And the case of Brecknell is a case which illustrates, I wonder, can we hand out copies? Sorry. One more.
Okay.
I'm really only highlighting this case to illustrate that this is a case in which the court didn't make an award of damages for breach of the promptness requirement. The case was an unusual one in the sense that the deaths occurred in 1975. There had been an investigation. There were a number of convictions resulting from that investigation, but new evidence emerged in 1999 in which a former police officer with a conviction for murder made detailed allegations about RUC collusion with loyalist paramilitaries. And that triggered a further investigation by the police into the circumstances of the shooting. So there was a fresh investigation subsequent to 1999, and that investigation took a number of years to resolve. But what the court observed at paragraph 72 of the judgment is the extent to which the requirements of effectiveness, independence, promptness and expedition, accessibility to the family and sufficient public scrutiny apply will again depend on the particular circumstances of the case and may well be influenced by the passage of time as stated above. Where the assertion or new evidence tends to indicate police or security forces collusion in an unlawful death, the criterion of independence will generally remain unchanged, and they refer to Ramsay. Promptness will likely not come into play in the same way, since, for example, there may be no urgency as regards the securing of a scene of the crime from contamination or in obtaining witness statements while recollections are sharp. Reasonable expedition will remain a requirement, but what is reasonable is likely to be coloured by the investigative prospects and difficulties which exist at such a late stage. So, Lady Arn, I don't know whether that meets with some of the questions you've been asking, but they clearly recognise that if you're investigating an incident in 1975, but you're now investigating in 1999, different criteria apply to what is prompt and what is reasonable expedition. And in this case, although there had been a very lengthy and protracted investigation, they don't find a violation of the promptness requirement they do find a violation of the requirement that there be independence for the start of the period, and they did award non-pecuniary loss in the sum of €5,000. The discussion on promptness and reasonable expedition, sorry, perhaps I should take you to this paragraph as well. For completeness, is paragraph 78. It's over the page, it's internal page 18, and it says the court considers the RUC took up inquiries without undue delay. If the matter has dragged on from 1999 to 2007, that has largely been due to the lack of any strong leads, difficulties in interviewing Weir, who remained outside the jurisdiction. It is not apparent that there has been any willful foot dragging or prevarication. The court also takes into account that a considerable number of other cases were being simultaneously reviewed over this period. While there might nonetheless be a question mark as to the slowness of progress in the early stages when the RUC were in charge, the court notes its finding of lack of independence above and finds no separate issue arising in the circumstances. No breach of these requirements has been made out. So I think that does give you a flavour that the court will, in certain circumstances, acknowledge that there are particular difficulties in particular types of cases and will take on board. And that, again, was not a case in which there were oral hearings. This was as a result of the exchanges between the parties on the papers.
Could there be a difference also between those cases where the claim is based on the failure to begin the inquest at all and those where the inquest has begun, but there have been delays in carrying it through?
I would imagine so. Mr. Carr will no doubt appreciate this comment. We're both involved in an inquest at the moment, which there were delays in it starting it, but there are delays in its currency caused by the fact that the the person who fired the fatal shots has at various occasions submitted that he's not fit to testify. That is causing the inquest to be severely protracted. That clearly is not the fault of the public authorities, and one can see one can easily see that one couldn't criticise the public authorities for that kind of complaint. And I think looking at the Brecknell decision, it does, I think, provide some comfort that the court will look at the explanations that are advanced for delay and consider.
Now, just now, you're really dealing with the issue of liability.
Yes.
We agreed earlier, I think, that a person who claims that their convention rights have been violated has a statutory right to bring a claim before the court. Now, the court then has to consider whether there has in fact been a violation of the convention right. It can't decline to adjudicate.
Yes, that's correct.
Right. Now, there's then a question whether it finds that there has been a violation. And that's really the issue that Lady Arden, I think, has been pressing you on. If the court does find that there has been a violation, is it not then required by Section 8 to consider the appropriate form of relief in order to afford just satisfaction for the violation?
Yes. My Lord, maybe I should have said this at the outset. We say the approach taken by the judge at first instance is impeccable in terms of the approach to the issues. He scrutinises the conduct, he establishes a violation against one public authority, he dismisses a violation against another public authority. He then reviews the Strasbourg authorities on damages. He considers the issue of whether just satisfaction is appropriate. He takes into account that in the instant case, Mr. Jordan has been awarded just satisfaction previously. He says that's a factor to which he will have regard, but he nonetheless notes and observes that the period of delay since 2001 is in fact greater than the period of delay that the court was critical of, and he concludes that an award of just satisfaction is appropriate, and he makes that award against the public authority that he attributes responsibility to. He makes a number of other observations about how other public authorities should deal with that, and we say, and then of course the only, from the point of view of the PSNI appeal, the only issue that the PSNI appealed, they weren't disputing the declaration. They were accepting that there could be a declaration. They said the question is, are damages appropriate? Now, they make a number of different complaints in making that. They A, question whether damages are appropriate at all in this case, but B, if they're going to be made, why should they be made against us when you have this problem of endemic delay? But we say those issues should have been and could have been addressed and dealt with within a short time. There was really no good reason to adjourn the case. But in adjourning the case, we say the court doesn't follow a line of Strasbourg authority, which is in front of it.
Sorry, I mean, I think you're missing the point with respect. As I understand it, what's being said is the court is bound, having A, decide whether there's a violation, and B, to decide whether to award damages. And you said yes. But I'm not sure that's right, is it? I mean, looking at Section 8, which is remedies, the court may grant such relief or remedy or make such order within its powers that it considers just and appropriate. And I don't think you're saying that the Chief Justice didn't have the power to make the order he did, are you?
No. And
So, I mean, had he not included the proviso about no exceptions, then I think you said earlier it would have been difficult to complain. So,
yes,
you accept that he was entitled, as a matter of case management, to make an order that the issue of damages should be put off until the inquest was complete.
I think my difficulty with that proposition is that the reason why he does it doesn't. It appears to me to come back to this issue.
Well, the reason why he does it, as I understand it, and please correct me if I've got it wrong, is that obviously there having been a violation found, there is an entitlement to just satisfaction. The question is, what is just satisfaction? Is a declaration sufficient? Is some other order sufficient? Or is there a requirement for damages as well? And he says until the inquest has been concluded, he can't choose between those various things, or it's difficult to choose between those various things. That's, as I understand it, the reasoning for the delay, not only in this case, but in most cases. We have to ask whether that's good enough reasoning.
I'm grateful for your formulation of the issue. We say it isn't a good enough reason. We say if this applicant had been, if this case was being heard in Strasbourg instead of in the Court of Appeal, Strasbourg wouldn't have said, we can't consider this until the conclusion of the inquest. We can't look at this. I mean, you'll see that Strasbourg does take an approach in McCaughey, in Hemsworth and MacDonald, where it says it is premature for us to look at the other aspects of Article 2. It's premature for us to look at overall effectiveness. It's premature for us to look at transparency issues. So the other minimum requirements which are identified, it says we will look at that in the round at the conclusion of the case. And it gives the applicant, it dismisses the case without saying you can't come back to us. At the end of the process, if you're dissatisfied, you can come back and make your complaint. But in delay, it says delay is different. We can look at this now, we can make a determination now, and we can reach a conclusion now. And we say, in the light of those judgments, the decision of the Court of Appeal isn't justified. They could decide at this point, Ms. Quinlivan, we're not satisfied that at this stage your client is entitled to damages, but come back at the end of the procedures and we will look at this again and dismiss our claim. But we say that the approach they took really isn't consistent with the Strasbourg jurisprudence in front of it, and it does have the impact of effectively preventing the appellant from availing of the remedial structure of the Human Rights Act.
But they say, well, there are categories of case. For instance, those where no inquest has been opened, let us say they could say, or decide if this was appropriate, that there was no good reason for not opening the inquest and fixing the penalty and so on. And that those cases, there would be claims for compensation which could be dealt with immediately. Then once you'd started the inquest, and if it was a complex one, they wouldn't, they may say, it's obviously a matter for them, that it's not or it's not convenient to take a view because they could only give you compensation up to the day of the judgment, and then have another claim which they'd have to deal with separately, and it could give rise to findings of inconsistent findings. Broke up the claim once the inquest had opened.
I suppose the only question mark would have about that is what we mean by because all of these inquests open, what happens is they formally open shortly after death. But I think what you're asking me is in terms of the inquest starting to hear evidence.
The activity.
The actual active. I can certainly see a logic in the court saying that once an inquest is started and evidence is being received and and there are inquests before the courts which, for a variety of reasons, have stopped and started. The court could say, well, that category of case, it's really arguably not appropriate. I think they would always have to acknowledge that there have to be exceptions to the rule, which is one of the concerns about it. But the import of the Court of Appeal judgment, we say, is so broad as to be unsustainable. One can clearly see, and I'm not suggesting there can never be case management practices put in place in order to manage litigation. But what has happened in this case is that the principle that the Court of Appeal has outlined is so broad in its sweep that it prevents someone taking their claim for damages, even if they've waited 25 years to have their inquest come on, and in circumstances where there's no imminence to the inquest. It's not an inquest that's going to be heard in the next month or 6 months or a year, but also that they can't seek a declaration and they can't seek mandamus to say the coroner should do X, Y and Z or the police should do X, Y and Z in order to progress this inquest.
We find the reasoning of the Court of Appeal in paragraph 20. I think that's where they... Yeah, well, in 20 what they say is, this is where they are reaching a conclusion by reference to principle. They say it's a common case that delay in the hearing of inquest proceedings can constitute a breach of a convention and thus entitle an aggrieved party to bring proceedings. So delay entitles the party to bring proceedings for breach of a convention right. So that's where we started off, section 7.
Yes.
The appropriate remedy for such a breach will depend on the circumstances of what constitutes just satisfaction, but may include an award of damages. So that's section 8.
Yes.
Declaratory relief or mandamus may be enough to secure the right. We have ordered in this case that the inquest should now proceed before a different coroner, so they have given a mandatory remedy. If that inquest does not take place within a reasonable time frame, that would constitute a fresh breach of a convention, for which a remedy, including damages, may be available. So they're contemplating that having found one violation and granted a remedy for it, there may be another violation in the future.
Yes.
It's when the inquest has been completed, it would be possible to examine all of the circumstances surrounding any claim for delay, and the court will then be in a position to determine whether adequate redress requires an award of damages, and if so, against which public authority in which amount. Now, I may be wrong, but my impression from that is that there is a concern that there may be repeated breaches of the convention, and in order to avoid a proliferation of claims, the court prefers to wait until the end of the inquest so that all the infringements of the convention can be dealt with at once.
Yes, I understand that. It seems to us, however, that there was nothing to preclude the court determining the claim against the PSNI in 2015 and reaching a decision. And if we had then come back in 2016 and said there's been a further delay of a year in the conduct of the inquest and we are unhappy again about delay, that the court would have regard to the fact that we had just satisfaction in 2001 and that we had a further award of just satisfaction in 2015. And really, I think it might be regarded as an abuse of the court to come back for a further claim. So I can readily see how such a claim would be dismissed. It doesn't seem to me to necessitate waiting until the until the conclusion of the inquest. And I think, as we've acknowledged, that if you didn't have the general statement that followed, I anticipate the court would have been slower. I don't know, obviously. I anticipate the court might have been slower to grant leave, but it is the general impact of this decision that is also part of our complaint and our concern before the court, not just the discrete application to this particular appellant. I don't know whether that...
It's obviously very unusual to justify a refusal to award damages for a breach of a person's rights on the footing that there may be another breach of their rights.
Yes.
And will save court time in the long run by dealing with all the breaches at once.
Yes, and my friends say again, look, no particular prejudice occurs to the applicants, but we say that might be true in terms of this appellant's eventual award of damages. I mean, I should say, one of the features of the case as it ran in May of this year is no additional evidence was filed by any party. We ran the case on the basis of precisely the same material as we would have run the case had we run the case in 2015. The court didn't invite further evidence or further information. There was no complaint about delay in the judicial review or complaint about delay in the subsequent inquest. So the reality was that all you have, in fact, is a significant delay of almost 2 years in a hearing which was ready to go on the 22nd of September. But there certainly might be cases, you will have seen that at the same time, and I'll just give your lordships the reference to the judgment at this stage, but it's one of the judgments that's before your lordships as part of the case. You'll have seen, and it's volume 1, tab 5, you'll have seen that at the same time as Mr. Jordan's application for a remedy of damages against the Chief Constable was heard, Mr. Justice Stevens dealt with 5 other applications for judicial review, which had been taken separately but joined together. So these are all cases in which the applicants complained of investigative delay, and the circumstances of each case are outlined at MS 817 in very short form. And paragraph 13, limited background information was presented on behalf of the 5 applicants, and you'll see at A, Kathleen Ryan is the mother of Michael Ryan, who on the 3rd of June 1991 was shot and killed by members of the SAS with 2 others at Coke in County Tyrone. Hugh Jordan, your lordships and ladyships are familiar with the case. Christina McCusker is the mother of Fergal McCusker, who was some 16 years ago shot and killed in Mahara, and there were concerns about collusion between loyalist paramilitaries and agents of the state. Over the page, Colette McConville is the mother of Neil McConville, who was shot by police by the PSNI on the 29th of April 2003. There is the factual background my lord refers to comes from the police ombudsman's investigation of the circumstances of the death. Then Anne McMenamin is the mother of James Daniel McMenamin, who some 8 years ago, in 2005, died as a result of being knocked down by a PSNI Land Rover as police were on their way to deal with an emergency call. Jordan Brown is the son of Stephen Caldwell, who some 8 years ago in 2006 was shot and killed by a PSNI officer. He was driving a stolen car and a police checkpoint was in operation at that location. So the court dealt with those 5 cases for damages at the same time and without difficulty and awarded damages in each of those cases. Now, if we take the case of Kathleen Ryan, where the death occurred in 1991, where she received an award of damages in 2014, and where we're now in 2018 with no imminent prospect of an inquest into that death. If another 2-3 years were to pass, which is not unrealistic as matters stand, it seems to me that there is no reason why Mrs. Ryan should not be able to complain that, you know, I'm a person who's never had an inquest into my son's death. I've had just satisfaction in the form of damages, but actually I would like an order of mandamus in order to compel an inquest into the death. I would like the police to take certain steps. I would like the coroner to take certain steps. And I would like you to consider whether just satisfaction is appropriate. Mrs. Ryan is really in no different a position than other applicants who have debts of similar vintage, but who are now unable to advance their proceedings. So Mrs. Ryan potentially could by virtue of the fact that her case is brought and precedes the Court of Appeal's ruling, she can be the beneficiary of potentially 2 payments for just satisfaction, in contrast to other persons whose deaths are of the same vintage, who have actually initiated proceedings at in and about the same time. And we've referenced the cases of Dillon, Bryan and O'Donnell, and I can take you to the detail of those cases in due course, but deaths in 1992, 1997, but by virtue of the Court of Appeal judgment, they can't advance their case. That illustrates, we say, the prejudice that is potentially caused. If you have a system where you have endemic delay, applicants must be able to bring their cases to the court. But if that delay continues, they must be able to bring their case to the court again to see if they can get an adequate remedy. And most people's remedy would probably preferably be mandamus rather than just satisfaction. But the option must be open to them. Sorry.
You're effectively turning it round and saying there's a presumption that the cases should be allowed to proceed unless there are circumstances where the judge finds that it's inappropriate to meet the ends of, in accordance with the aims of justice, to hear the case then.
Yes. Yes, and I think that is the starting point if one looks at the Strasbourg jurisprudence.
It's said against you that the effect of the Court of Appeal decision is that it creates a presumption the other way.
Sorry, my lord,
It's said against you that the effect of the Court of Appeal decision is that it creates a presumption the other way.
Yes.
But your submission, as I understand it, is that it goes much further than that.
Yes, we do say it goes much further than that. We've referred to, and to give an example of the impact of the case, we referred in our petition to 3 cases which adjourned as a result of the decision in Jordan. And if I could ask you to look at the annex which the third respondent has provided, just to give you a flavour of what we say the impact is, and it may be helpful. Sorry, the annex commences at MS 166.
Yes.
It's in the core volume, and I'm going to commence from MS 169. And just to compare and contrast, the case of Michael Ryan, which I've just referred to, which is one of the Jordan and others cases where Mrs. Ryan obtained compensation, it's the very bottom case on page MS 169. So you'll see the reference to Mr. Ryan and the 2 others shot and killed at Coke in County Tyrone. Then if you go to the next page, MS 170, and the second case in the list, that's the case of O'Donnell, and that is a case in which leave to apply for judicial review. You won't find this in the papers, but we can put it was granted in September of 2014, and the proceedings were stopped in June of 2017. So that's a case that the impact has been that the applicant cannot complain of inquest delay, either in terms of seeking a declaration, just satisfaction, or mandamus.
You say proceedings stopped, they were stayed completely?
Yes, as a consequence of following on from the guidance from the Court of Appeal. That's also true of the case of Sean Bryan, which is 3 cases further down. So you'll see John, also known as Sean Patrick Bryan. It's 5 cases down the list. It's a death which occurred in May of 1997. It was opened by the coroner in May of 1997, but no inquest has commenced. And again, that case is not. Again, leave was granted to judicially review various public authorities in relation to delay. Those proceedings were lodged in January of 2015 and stayed in 2017. And then 2 cases further down, the case of Dillon was again stayed. 3 cases were heard alongside each other in relation to case management issues. But
sorry, all those 3 cases you say were stayed at the same time?
Yes, they were, yes. In June of 2017. We say that simply is illustrative. I should say there have been other cases as well, but that is illustrative of the impact. And of course, the reality is, and I've been asked to advise, the reality is the import of, I would submit on any reading, the import of the judgment of the Court of Appeal is that if you were asked to advise as to whether there's merits in pursuing an application to challenge inquest delay, you would have to advise that there currently is no merit because the Court of Appeal judgment stands and the Court of Appeal judgment will be followed by the High Court. And there's been no case that my friends have been able to illustrate to you, despite the incredible vintage of some of these cases. Nobody has been able to say, look, actually, here's the exception. This is the case that was out of the ordinary that the court said. And the three cases that I've identified, I would submit that on any analysis, when one is looking at delay from 1992 and 1997, it's difficult to envisage that there could ever be a response to delay that would be adequate to meet the requirements of promptness and reasonable expedition.
Could you just remind me of the one in the middle? I got the O'Donnell case, and I have got the Dillon case, but I
just two up from Dillon is John, also known as Sean Patrick Brown.
Patrick Brown?
Yes.
So that's a 97 death as well?
Yes, it is.
And Dillon is a 97 death. Yep. Yes.
I've been helpfully reminded just in terms of, and this is taking things out of sequence, and I do apologise. I didn't pick up the note when I should have. In terms of the discussion that took place about whether or not the European Court of Human Rights will scrutinise explanations advanced by the court, and perhaps if I just give you the reference, Shanahan is another case in which the court looked at the explanations advanced in terms of delay and either accepted or rejected them. And, sorry, Shanahan you can find at Volume 1, Tab 10. The reference is MS 994 and it's paragraph 119. It just refers back to the discussion we've been having earlier. My Lord, just give me a minute and I consider whether there's specific matters that... I think we've discussed the judgment, and I don't unless there's any particular passages in the judgment of the Court of Appeal beyond those that I've already raised, I wasn't proposing to deal at length with the judgment.
Can I just ask you about the last sentence of,
yes,
of paragraph 20? Because this is really the one which I think the respondents focus on. It's when the inquest has been completed, it will be possible to examine all of the circumstances surrounding any claim for delay, and the court will then be in a position to determine whether adequate redress requires an award of damages, and if so, against which public authority, which amount. Now, I think this again has to do with avoiding more than one claim having to be adjudicated on whether there is more than one violation.
I think that's right. And
because if you have a violation prior to the holding of the inquest and the claim is before the court can then examine all of the circumstances surrounding that claim for delay. Yes. And it's in a position to determine whether adequate redress in respect of that violation requires an award of damages, and if so, it can determine which authority ought to pay the money, because it can look at the reasons for that delay.
Yes.
And in what amount.
Yes, yes. And
so I think this is consistent with the reasoning in the previous sentence, that it's really in a situation where there are successive breaches of the convention, that there's going to be a saving of court time by rolling up the whole exercise into one claim.
It seems to rest on a presumption, potentially a presumption that there will be successive breaches, and I should say we don't make a complaint about delay in terms of the conduct of the inquest post the quashing of the judgment. But also, in some senses, a presumption that the system has the potential to be open to abuse by applicants. But we would say that the court can quite easily deal with. I mean, if the applicant had come forward a year after, so the inquest is completed a year later, we've had our just satisfaction in 2015, and we make our complaint, one can easily see that a court can dismiss an application for leave on the basis that your case isn't arguable, and make a finding, and the applicant can then decide whether they wish to appeal that and pursue further remedies. But it does appear, based on either a presumption that there will be repeated violations or that there will be some abuse on the part of applicants. And certainly there's no evidential basis for saying that applicants have abused the system. There have been when you consider the delay that exists, there's in fact been relatively few cases, and most cases have been linked with trying to persuade public authorities to take certain steps to progress the cases.
Could I just say,
yes,
Chief Justice not be saying there will then be really what he's doing is really referring to allegations of further breaches rather than to there being further breaches. And might there also be a risk of inconsistent findings? Suppose that damages are assessed on the basis that there's been delay because a witness was not fit to give evidence, and that no steps were taken to find substitute witnesses or whatever. And then later it appears that the real reason was that somebody had failed to disclose a document which might have obviated the delay which then occurred. Could you get, that's perhaps a bad example, but could you not also have a risk of inconsistent findings and awards being made on one list, which were falsified by the time you got to the end of the coroner's inquiry?
Theoretically, obviously, there are circumstances in which that could happen. In this case, in terms of the manner in which it was presented, really, we were, and I think it's important to emphasise, we complained of delay from 2001 until the date the inquest opened. We didn't make any complaint about what happened once the inquest started, and we would have had no basis for it. I'm not suggesting we would. But so we were looking historically through a prism of disclosure was given on such and such a date, or it wasn't given, and the reason why it was given. Disclosure was the main criticism that was made of the PSNI ultimately in the judgment of Mr. Justice Stevens. And those matters, it seems to us, could adequately be dealt with. There was nothing in the features of this particular case that would say there may be something that will emerge subsequently because the disclosure is provided on a certain date or it's not provided on a certain date. It's satisfactory or it's not, and the court can scrutinise that looking backwards. And of course, the PSNI were represented.
So to facilitate the proceedings and in order to save impact on judicial resources, which are no doubt scarce, one could perhaps consider a situation where there's a standardised amount for the inquest having been opened but not been acted. And after that, the cases should be perhaps left till the end of the inquest.
Well, maybe
in general.
One can envisage that the public authorities could sit down and view the situation. I mean, on any analysis, everyone will acknowledge that there are clearly cases here where there's been delay. I suppose the approach taken in the 5 cases that were heard alongside Jordan, so 5 cases involving different public authorities, some overlap in public authorities, but not identical authorities in each cases. In all cases, the coroners had said, well, we have a difficulty in advancing these inquests because of resources. The Department of Justice was joined as a party, and the Department of Justice decided that rather than have a dispute between the police ombudsman and the PSNI about who was responsible for what, that they would take responsibility for delay. A general declaration was agreed, which didn't point the finger at any particular party, and we on the part of the applicants agreed to that approach. And then the dispute was, well, should you get just satisfaction or not? And a discreet and manageable hearing took place, which simply revolved around the question as to whether just satisfaction was appropriate. There are clearly effective case management methods of dealing with this, which meet the justice of the case and met the justice of the case in those cases, without the concern for proliferation. And the approach in that case was to hear 5 cases. They were all brought by the same solicitor and had commonality in terms of counsel, but to deal with the 5 cases together, despite the fact that there were a variety of different public authorities, and it was dealt with in a manner which was effectively managed. And of course, the Department of Justice didn't take issue with once Mr. Justice Stevens decided that just satisfaction was appropriate. The Department of Justice accepted that judgment, and the matter was dealt with. So that, it appears to us, as a case management approach which meets the needs of managing judicial resources, meets the justice of the case, and doesn't create the kind of problems that in fact follow from this. And one can imagine that course having been taken in those 5 cases, which were really the first cases, aside from Jordan, to proceed, that it provided a template by which cases could proceed thereafter, in the sense that respondents now would recognise that the approach of the court is to make an award of just satisfaction. They've identified this standardised amount, and in any event, it seems, again, of course, we're simply indicating that we endorse the approach taken by the trial judge to this case and to the related cases that he in fact dealt with. I'm just keeping an eye on the time. Sorry, my lords and my ladies, I'm just going to check that there aren't any particular issues that I haven't addressed to your lordships and your ladyships. I think we probably have covered most of the territory. So,
well, you've got another 20 minutes.
Yes, I'm
so
conscious.
Do make sure that you have.
Yes.
Because we've thrown a lot at you, but that's enabled you actually to make your points, I think.
That's what I'm just checking, that I had. There is some points that I wanted to make that I've neglected in the course of proceedings. My friends do make the point against us. They do make the point against us that the approach of the Court of Appeal was consistent with the rules of the court and the overriding objective. I have to say, we take some issue with that. It appears to us that, in fact, that the approach has been, and I am undoubtedly not intentionally, but less than effective in terms of case management approaches. You'll find the relevant rule at volume 2A, tab 13. I make a very brief point about this. Sorry, the MS number is 1005. I think my friends seek to say that the approach taken by the Court of Appeal meets with the overriding objective, presumably in terms of saving expense, dealing with the case in ways which are proportionate to the amount of money involved, the importance of the case, the complexity of the issues and the financial position of each party, and ensuring that it is dealt with expeditiously and fairly. We would simply point to the fact that in reality what happened was a case was adjourned from September 2015 through to May 2018, and then was heard on the basis of exactly the same facts, exactly the same evidence, and really all that's happened is we've had intervening hearings, but essentially unnecessary delay in the resolution of this issue, and we say that delay was unnecessary and in fact disproportionate really in terms of approaching the case. So we don't consider that the overriding objective particularly assists my learned friends. But I think, my lords, my ladies, I probably have... Sorry.
Can I just ask
yes,
I have one question? There's quite a lot of concern in, perhaps more Mr. Justice Stevens' judgment, but in identifying the public authority which should pick up the bill
Yes.
I was just wondering, the Department of Justice is a part of the Northern Ireland Executive. Is that
Yes.
right? The Coroner's Service, is that an executive agency of the
It's
of
an
Northern
agency of...
Ireland? Yes.
No,
So those are actually in law, they're the same legal
no,
person.
I think imagine the Department of Justice will answer this question better than me, but the Department of Justice does fund the Coroner Service,
Yes.
provides the funding for the Coroner Service, and it was that factor that led to the Department of Justice being joined in the other cases, because the coroners were saying, well, we can't do this, we don't have the resources, and the Department of Justice was joined.
The Coroner's Service is a judicial service.
Yes.
So it's a bit like the relationship between the Department of Justice and the courts.
Yes. Yes, it is independent, obviously. Yes.
Well.
Obviously.
Yes, we don't need to.
But resources obviously can hamper your ability to do your job, no matter how independent you are.
And the Chief Constable, that's another body funded by the
It is not totally funded by the Department of Justice, but it receives funding from the Department of Justice. So it would be independent of it. But I imagine my friend will be able to better articulate the nuances of that. Unless there's anything further at this stage, my lords, my ladies, those are my submissions.
I think we've thrown quite enough at you. Thank you, Ms.
Thank you.
Ms. Doherty? I think Dr. McGleenan.
My ladies, my lords, I here on behalf of the Chief Constable. Perhaps at the outset it'd be useful to clarify what is still an issue before the Northern Ireland Court of Appeal in respect of the Jordan case. We received a judgment last week in respect of the challenge to the second inquest verdict, which had been ongoing. The court dismissed that challenge, so the inquest process, subject to any further appeal, has reached its final destination. So we are now certainly at a juncture where a full and comprehensive assessment could be made of the issues that arise from the inquest. There is an ongoing issue before the Court of Appeal. That is in respect of the Chief Constable's appeal from Mr. Justice Stephen's decision in 2014. I can summarise it this way. That appeal is about the question of entitlement to damages by way of just satisfaction, apportionment as between a range of public authorities, and the issue of quantum if there is to be an award of damages. So those points about which we have spent some time engaging this morning are live before the Northern Ireland Court of Appeal, not before this court, certainly not yet. Those points, as I say, we do not require a ruling on at this stage. The issue that is before the court is the judgment and order of the Northern Ireland Court of Appeal in September 2015, whereby it stayed the element of the appeal relating to the issue of just satisfaction. And we, in our written case, have characterised that as a case management decision. Case management decisions we've submitted ought to be the subject of light touch review, and only in exceptional circumstances should be reversible on appeal. The authority for that is the AB and Sudan case, which we included in a supplementary bundle, which we passed to the court in the last week. And we say this is probably to be considered a case management decision when one has regard to the judgment and order itself. The court has seen the judgment and the operative passages of it are at MS 184 and 185. The order of the court is to be found at 176 and 177. Could I ask the court to turn up the order?
So did you say 186?
176 and 177 for the order, my lady.
Yep.
And the order of the court was confined to the claim for damages. There's nothing in the order that precludes an applicant from bringing an application seeking other remedies by way of declaratory relief, certiorari, mandamus, or any other relief open to the court. The Court of Appeal ordered that the claim for damages in this case, in respect of the properties of the inquest, should not be brought until the inquest has finally been determined. Of course, the claim for damages had already been brought. The live claim was lodged in April 2013.
Yes, I mean, there's a discrepancy between the wording of the judgment and the orders.
Yes.
The judgment says it ought not to be dealt with,
Yes.
or it ought to be dealt with once a minute. Whereas to say it should not be brought, as you say, it had been brought.
It's been brought.
The really effect is to stay it rather than...
Exactly.
It seems to be interpreted in some of these other cases as meaning that the case can't be brought at all.
Well, I'll come back to that issue about how it's been interpreted in other cases, but our submission is that the judgment must be read with the order, Order 53 statement lodged in April 2013, where the appellant brought a claim for damages, a claim which was processed by our High Court and an award made. What the Court of Appeal are saying is that this claim for just satisfaction and damages, if appropriate, should not be finally determined until the inquest process is at an end. And we say that is classically a case management decision within the remit and scope of the Northern Ireland Court of Appeal. But, my ladies, my lords, one should also not lose sight...
Just a query. I mean, is there any reason why the numbering on pages 177 starts again? I mean, we have court orders 1, 2, 3, and then carries on 1, 2, 3, 4. I wonder whether there's something missing.
There's nothing missing, as I understand it. That's the complete document. It's there.
There are even different numbers. If you look at the reference number, the top left of page 176 is different from the reference number in the top left of 177. And similarly, the numbers in the top right-hand corners are different as well. It's as if they come from different documents.
We may have to chase that down. The order was...
Well, we have something, of course, the dating is so peculiar because of how things happened.
There was a correction of the Court of Appeal's judgment. The final corrected version did not emerge until much later, which may explain why we get it dating on the 10th of June 2017. But
it'd be nice to check that we have the right a single document and it's the right document.
We'll undertake to have that checked. But
Well, what was the order made after the first judgment, first version of the judgment in September 2015? And how, if at all, did that differ from the order made after the revised version of the judgment in May of 2017? It would be quite nice to know that.
our understanding is that there wasn't an order made after the first judgment.
There wasn't an order?
No, there wasn't an order made. There was an issue about the correction of the judgment. The judgment was duly corrected, and the order ultimately extracted is that which appears in page 177. What's important for present purposes, we say, is that there's nothing in an order or the judgment of the Court of Appeal which precludes an applicant from bringing a claim at initiation stage for damages, nor is there anything in the Court of Appeal judgment or order which prevents someone seeking other remedial orders in respect of an alleged breach of Article 2. So the access to the court point, which is part of the case made by the appellant here, we say is misconceived. We also say...
If so, it would be a good idea if the court order didn't say should not be brought.
Yes, but that is, as a matter of logic, something that doesn't sit at all with the pleadings the court was dealing with, and by the fact that the claim had been brought, determined in the applicant's favour. My Lords, we also say that the appellant adopts an extremely narrow reading of the Court of Appeal's judgment and ignores the fact that the court was, in the paragraphs that are impugned here, paragraphs on pages 184 and 185, the court was actually giving an expansive interpretation to aspects of the Human Rights Act, which would enable access to justice for those who claimed just satisfaction for breach of Article 2 promptitude requirements. And I say that, my ladies and lords, because when one turns to paragraph 19 of the judgment, that's MS 184, you will see that the issue the court was grappling with was how to deal with the situation where one had a period of delay stretching over a decade. One had multiple state actors variously responsible or denying responsibility for that period of delay. And you had an issue as to how Section 7 of the Human Rights Act would be applied in that context with its limitation periods. Because one faced a situation where over the course of a decade, some of the apparently culpable state actors would be out with the reach of the Human Rights Act because of Section 7. And that was a live issue in the Jordan case, because the only state actor for whom responsibility had been attributed was the Chief Constable for a period of time in 2009. But of course, the state of coronial law was not the responsibility of the Chief Constable. The accessibility to legal aid was not the responsibility of the Chief Constable. The availability of coroners was nothing to do with the Chief Constable. Those were matters that fell for consideration in respect of other public authorities. And the issue for the Court of Appeal was, how do we manage that point? Are we to adopt a strict approach to the application of Section 7, which will preclude meritorious delay claims from progressing because they haven't got the right state actors in the right time frame? And what the Court of Appeal were saying in paragraph 19 of the judgment, importantly we say, benevolently in some views, and to the benefit of the appellant, was that one would adopt a presumptive approach whereby all public authorities would be joined to a delay type challenge, and there would be, again, a presumptive extension of time so that the Section 7 guillotine would not fall and preclude the claim. So the court was giving, we say, an interpretation to the Human Rights Act that was of assistance to those bringing claims of that type.
It's not an issue we need to decide in this case, but there's a real question, I think, about whether that approach of trying to pin responsibility for the delay on a particular public authority is actually the best way of dealing with this.
That's exactly the issue which the Chief Constable's brought in his appeal that's still before the Court of Appeal, because the argument is that's not the correct approach. Yeah. Because what you will do is identify or not identify the actual systemic problem, and you will fix liability on a symptom of the problem rather than addressing the actual cause. Yeah. So that's, I agree, not for this court.
And apart from anything else, the person who's responsible for the delay may not be a person who has actually infringed any convention right of the claimant.
Yes. Respectfully agree, my Lord. There are a multiplicity of difficulties with that issue, and that's not a straightforward point, and we look forward to the Northern Ireland Court of Appeal's analysis of that. But what our Court of Appeal were saying in this case was to deal with the potentially detrimental impact of Section 7 in paragraph 19. You'll see at the top of page 185, if each case had to be pursued within 1 year of the end of each particular element of delay, that would have produced a proliferation of litigation in respect of which period of delay justified an award of damages against which public authorities. Practicality and good case management point towards ensuring that all of those claims against each public authority should be heard at the same time. And paragraph 21, they then say the way in which we can avoid the strictures of Section 7.5 is to adopt an approach where presumptively we will extend time to allow all public authorities to be captured. So this judgment, we say, was directed to an approach that would allow for efficacious case management and also to ensure that any systemic problems in Article 2 delay were properly directed and addressed to the correct authorities. On the facts of this case, in paragraph 20, the court were saying that the proper common sense approach, rather than to have a sequence of claims alleging a breach of promptitude, is to wait until the inquest itself has concluded. And of course, this court will not have lost sight of the fact that in this very same appeal, this same court had ordered that the inquest proceed. It had directed a fresh inquest in the same proceedings. So it had rejected the Chief Constable's appeal against the quashing of the 2012 verdict, directed a fresh inquest take place, had in anticipation and within view, we say, the completion of that inquest, and in that context said it would be better to wait. We can address all issues when all issues have crystallised. Now, reasonable people may take different views about that, but we say the view that the Court of Appeal took was an eminently reasonable one. We also say that the Court of Appeal...
You say in principle that it's a proper exercise of case management powers to decline to give a remedy for what is a completed violation of convention rights at that time,
Yes.
in anticipation that there will be further breaches of convention rights.
Yes, what the court
And
can see...
in the long run, you save court time by dealing with all of them at once.
The issue of delay was not contested in this case. We had already a declaration that there had been Article 2 delay. The issue was remedy, and at which point do we determine remedy? You could determine it at this stage, but it will be incomplete. And you know that because you've ordered another inquest. Not quite sure how long it will last. In
Well,
fact,
it would be a complete remedy for the violation that you've found.
yes.
It wouldn't be a complete remedy in the sense that if further violations occur, then they also may require some sort of remedy.
Sometimes we say in this context it's helpful to tease apart the underlying principle that applies to the promptitude requirement in Article 2. The promptitude requirement in Article 2 is directed, in our submission, to the investigative phase. There is a proper rational basis for urging promptitude in order that securing of evidence, securing of documents, witnesses, forensic material is discharged as quickly as possible. That's not what this case is about. This case is about the question of promptitude after you've made findings of Article 2 delay in discharging the remedy. And those imperatives for securing witnesses, forensic material, documents are not in play. So much of what the submissions my learned friend made to you in drawing attention to the Strasbourg jurisprudence were grounded on Article 2 delay cases, where the issue was failure to progress the investigations. That's not the issue with which this court is currently concerned. Here we're looking at post-finding of Article 2 violation and the question of at which juncture it is appropriate to determine just satisfaction. And none of those forensic considerations which go to the discharge of the substantive Article 2 right are actually in play at that stage.
Is there also a risk of awards being made on inconsistent bases of fact if they're made incrementally in the course of a coroner's inquest? If further evidence emerges or further events falsify the basis on which...
Yes, and in this case, we did have a further extensive inquest in 2016. That inquest considered new material. One of the complaints that might be made about that new material is that it should have been produced at an earlier stage. The ingredients of the Article 2 delay claim and just satisfaction would be informed by what happens in the course of the conclusion of the inquest process. Hence the logic of the Court of Appeal's position that we should wait and see how things finally crystallise.
They do refer to any disputed issues of fact.
Yes. So we had another factual inquiry. Much of the ground traversed was the same. Some of it was novel. Additional points may or may not be made about that. Now, it's also, we say, necessary to acknowledge that the Court of Appeal, in paragraph 22 of its judgment, was not closing the door absolutely. It didn't say there would be no exceptions to this approach. It did say it would be difficult to envisage exceptions to this approach. but it wasn't an absolute rule that admitted of no return to the court. And of course, that's evidenced by the fact on the 23rd of October 2017, the Court of Appeal did revisit the issue, went back of its own motion, and made another order indicating that we could now proceed to deal with the delay and damages claim. That was done. We had a substantive hearing in May 2018, and the issue was canvassed. So there wasn't an absolute bar. That's evidenced by this case. It is also, we say, important to reflect on the fact that the Lord Chief Justice, giving this judgment in the Court of Appeal, is also President of the Coroner's Service. He heads the coronial service in Northern Ireland. Since 2016, he has taken responsibility for the management of the legacy inquest caseload. The legacy inquest caseload in Northern Ireland is challenging in jurisprudential terms, challenging political terms, and challenging in resource terms. There are ongoing appeals in Northern Ireland about the extent to which Article 2 of the Convention applies to deaths that occurred pre-2000. We have 3 appeals in the Court of Appeal on which judgments awaited on that issue. The question of resourcing coronial inquests has also been the subject of litigation. You have the Hughes judgment in the papers, and it is presently the case that the coronial service is under-resourced for the discharge of this work. So when the Chief Justice, in his judgment, refers to questions of practicality and case management, he has within purview all of those jurisprudential, political and resource difficulties. They inform what is, we say, a pragmatic case management decision, which results in no denial of rights insofar as there is no denial of access to the courts. The issues will, in this case, be determined, and nothing in this judgment serves to preclude that. Now, it has been said that the import of this judgment has been to prevent other delay litigation progressing. The court has been referred to 3 particular cases, Dillon, Brown and O'Donnell. It is right that those were stayed in June 2017 by Lord Justice Weatherup. They were reviewed again by Mr. Justice McCloskey in January 2018, and he continued the stay in respect of those proceedings. We will extract the order of the court for your consideration. The important point about that is the rationale for staying those proceedings was the awaited Hughes judgment on resource allocation for coronial inquests and the outcome of this appeal to the Supreme Court. So it's not the effect of the Court of Appeal's order, it's the effect that the Court of Appeal's order is still subject to ongoing appeal, that our courts have said they will await the final determination of this issue. We will produce the orders over lunch in respect of that. It is open to any of those applicants to bring their applications back before the court. The orders expressly say there's liberty to apply. That could have been done before now if that was an issue that they wanted to pursue, and it can certainly be done once this appeal has been concluded and disposed of. There is an issue still as to whether or not, in a case where the inquest is not concluded, it is better to await the conclusion of the inquest. In cases where inquests have concluded, the matter ought to be relatively straightforward. We can move to a computation of damages if damages are appropriate. That can only be done once our Court of Appeal has ruled on whether or not just satisfaction requires the payment of damages in an Article 2 delay case. If it does not, declaration may be sufficient. If it does, then we have some ready indicators as to what the appropriate quantum might be. Turning to the appellant's argument. There's three core propositions at the heart of it. The first is that the Northern Ireland Court of Appeal have disregarded a clear and constant line of Strasbourg authority. We say the Court of Appeal clearly had the Strasbourg authority on delay in Article 2 within contemplation. They refer to the Jordan decision itself in paragraph 3 of the judgment. The procedural obligation is well-travelled territory before the Northern Ireland Court of Appeal, and it would be surprising if the court did not understand that there were promptitude obligations that attach to it. But our point about this is the Strasbourg jurisprudence says nothing about case management. It says nothing about whether or not it is appropriate to await the conclusion of all proceedings before making an assessment of just satisfaction. Indeed, if one looks to Section 8 of the Human Rights Act, Section 8 points towards a consideration of all the circumstances in determining whether or not just satisfaction is appropriate. And Section 8, we say, is a guide that the Court of Appeal have properly adhered to. It is right, and I do not dispute, that the Strasbourg Court have awarded just satisfaction in the form of damages in cases where the inquests have not yet concluded. But it is a non sequitur, we say, to say that it follows as a consequence that our Court of Appeal cannot impose a stay in cases of this type. The Strasbourg jurisprudence, we say, does not address that issue. It's also, we say, interesting to note that the approach that this appellant applicant took to bringing the claim that is live, the claim that was lodged in April 2013, was that that claim was only brought when the inquest concluded. The inquest in question at that time was the 2012 inquest. This litigation has its genesis in complaints about the promptitude of the 2012 inquest. The applicant didn't bring interim claims between 2001 and 2012. The applicant waited, we say correctly, until the inquest was over in 2013 and brought the claim at that juncture. So we say it's harsh to criticise the Northern Ireland Court of Appeal for adopting an approach which the appellant has in fact followed himself. The second limb of the applicant's argument is that there's been a denial of a right to bring proceedings alleging a breach of Article 2. And I note the observation that's been made in exchange that might be better characterised as an Article 6 type claim. There is no bar on either this appellant or any other bringing proceedings under Section 7 based on an allegation of a lack of promptitude. There are a number of jurisprudential uncertainties because of extant appellate litigation, some of which may find its way ultimately to this court. Those jurisprudential uncertainties have from time to time led to discretionary case management decisions by our lower tier judges to progress or not progress individual challenges. But there is, we say, no structural or systemic bar to such an application being brought. We've already highlighted to the court the fact that the rounded interpretation of the Court of Appeal's judgment illustrates that in fact the court has taken an approach that should widen access to those who wish to bring claims based on a lack of promptitude. The third element of the appellant's case is to the effect that the Court of Appeal is denying rights in a manner that results in them being theoretical and illusory. We say that's really a recasting of the other points. But the issue here, we say, is only about timing in terms of the ultimate resolution of remedy. The question of whether there has been a breach of Article 2 rights is not, we say, properly in play. I don't need to recite a great deal of authority in this case in respect of the approach that should be taken to a case management decision if the court accepts our characterisation of this application.
Well, that's the big issue, isn't it?
If the court accepts it, this court's already looked at Prince Abdulaziz. We've cited the authority. It's at tab 38 of the bundle.
The issue is whether this is properly characterised as a case management issue, is it?
And if it is, we say there's an inexorable outcome in respect of that. The court should be properly deferential, if that's the right word, to the Northern Ireland Court of Appeal, given its uniquely well-placed position to assess how to manage a vexed and difficult legacy caseload.
Case management decision can result in a violation, can't it? It's a question whether the case management decision was properly made.
Yes, conceivably a case management decision could, if it was framed in such a way that there was no recourse, if it, for example, was staying the actual Article 2 investigative process without resolution, so that the promptitude requirement could never meaningfully be made, then we'd be in different territory. But that's clearly not the situation we're dealing with. We're here dealing with post-consideration, and that's different. So, in our submission, this is within the range of reasonable decisions that's open to the Court of Appeal on case management. Abdulaziz is authority for the proposition that the court will only reverse that in exceptional circumstances. We say there are no exceptional circumstances, given that we have now had an inquest.
Would that be so in relation to those inquests which have never become active? And we're talking about compensation up to the time or before the time in which they do become active.
It might be different in respect of cases where there had never been any progression of inquest. But again, there is a strand of litigation in Northern Ireland about that. We have the Hughes litigation about the macro funding of legacy litigation in Northern Ireland. That is, we say, the stream of litigation that really goes to the heart of the issue, rather than dealing with symptomatic representations of the problem, which is really what we're seeing in cases of this type. The real issue is how should or who should fund and resource legacy litigation, if that is the way in which we're required to discharge the Article 2 obligation. That's not the issue before the court in this case.
No, but one could possibly envisage, I mean, I'd be interested in your reaction on this, that for those sort of cases where there's been no progression, that some kind of standardised sum was applicable.
Yes.
Unjustifiable delay.
Yes. And one can see the ingredients of that in Mr. Justice Stephen's ruling, because he took the approach that he wasn't going to engage in a forensic parsing of the different levels of grief, that there should be a standard award for delay, nor was there to be a parsing of the duration of the periods of delay. Now, again, those are issues which we will no doubt debate in due course in our Court of Appeal or other courts. But there is conceivably a scheme by which there would be a standardised payment for delay. The Strasbourg Court points the way in respect of that. Lords, ladies, those are, I think, the submissions I have on behalf of the Chief Constable. Unless you have other questions for me, I've, I think, traversed the ground that I wanted to address the court on.
It appears not, Dr. McLean, and thank you very much indeed. Mr. Coleman? Mr. Cole.
Ladies, Lords, I appear with Mr. McAteer for the Department of Justice. I suppose if it's agreeable with the court, I'll make a start of my submissions, 15 minutes until the luncheon adjournment, and I'm happy to use the time. So we say that the decision impugned by way of this appeal, the decision of the Court of Appeal, is sound in principle, it's sound in authority, it's sound in practicality. It is I think one has to admit, a context-laden decision, context-rich. I wanted perhaps in due course take you to some of that context when our friend Dr. McLean has touched upon it to a degree. It's also can be characterised as having a quite strong degree of flexibility, which my learned friend Ms Quinlivan plainly does not agree with, but we think that one can see the flexibility not only in the structure of the judgment, but actually in what's been done with it since. And also it serves as an opportunity to highlight the proper position or roles, relationships between the Court of Appeal and this court, which might be worth having a quick review of as well. So if one could turn first of all perhaps to the kernel of the judgment itself. As the court will know, it commences at MS page 179, and the kernel of the judgment, we respectfully say, can be found in paragraphs 8 and then paragraphs 19 to 22. So paragraph 8 is MS page 181, and it serves to remind that any person who claims that a public authority has acted in a way which is incompatible with the Convention right may bring proceedings against the authority for that unlawful conduct. And there is therefore an important distinction between the domestic system and the international system in which any award of damages is made against the state. Where different periods of delay are caused by different public authorities, each responsible authority must be joined. And then slightly further down that paragraph, there is an obvious advantage in ensuring that a victim's claim for damages as a result of the acts of a number of public authorities should be heard together.
Now, as I've indicated, this is quite problematical, but as I understand it, we're not being asked to adjudicate on any issue relating to this.
As my own friend has indicated, I think that's an issue that we expect the Court of Appeal to speak upon in the remaining judgment. There's one might say, my lord, a reasonable possibility that it's an issue that might, through that case, come back to this court, depending on what will be taken in due course.
It's always a reasonable possibility.
Absolutely, my lady, yes, indeed.
We have to approach it on the basis that it was seen that different public authorities might bear different shares of any damages award.
Respectfully, my lord, yes, I say that's right. And indeed, that's the point the Court of Appeal highlights here, that when my learned friend, for example, and I understand entirely why she seeks to do this, when my learned friend, Ms Quinlivan, places it in the context of what would Strasbourg do, then that's one thing. Of course, the court in Belfast is the court in Belfast, it's not the court in Strasbourg, and it has to apply the Human Rights Act, first and foremost, and it has to look to what section 6, 7 and 8 apply as the test, and that's what we expect to be the issue to be addressed in the remaining, one of the issues addressed in the remaining Court of Appeal judgment. When the matter makes its way, any matter makes its way to Strasbourg, the Strasbourg Court has been addressed quite correctly here today, of course. The Strasbourg Court doesn't have a fact-finding role to play, so it looks to what has the UK state done or not done. In the domestic setting, we say respectfully at the moment, it is necessary for the High Court, Court of Appeal, to look when addressing the issues of liability, to who should the liability be affixed, which public authority. That has a particular resonance when one moves away from the field of declaratory relief, possibly even mandamus, though I think it might cause some issues in mandamus, into a different territory of damages. It's quite possible, perhaps, for the court, High Court or the Court of Appeal to make an order of relief of declaratory nature, saying in a bold statement there has been Article 2 delay in either in the conduct of the inquest or in the commencement of the inquest. But it's a different matter to accord actual pounds, shillings and pence damages. Who is it going to award it against? Has to look to see which public authority is in the mix. So that's what we say is a very important point in this.
Ms. Niven pointed out, and maybe I totally misunderstood her, that it had been agreed that the issues would be looked at in the round with the Department of Justice kind of standing in for all the other public authorities, and then there'd be something equivalent to contribution proceedings between the other public authorities.
Just to be clear about where that comes, that came in the Ryan, Brown and other cases. It has not been the courts, it's been adopted in this case.
That's why I was puzzled, that's why I was asking you. But would it be a course that could be? adopted.
Well, in
which would
theory,
make sense.
yes, and indeed because in theory it happened in Ryan, Brown and others, and that in effect the department took the view at that time that it would step in, the award could be made against it, and then it would top slice effectively that of the various bodies which it's responsible for funding. The problem with that, as a principled solution to all of this, is that the Department of Justice is not responsible for all of the public authorities that experience tends to demonstrate will be involved in the mix in these regards. For example, it's not responsible for the Ministry of Defence, and many of these inquests, by the nature of them, involve shootings by soldiers, by the military over the years, and there are issues about disclosure, tracing of witnesses, things of that nature, which attach to the Ministry of Defence. So the Department of Justice could not properly take that on board for the Ministry of Defence. And in actual fact, in one of the series of 5 cases in Ryan and others, the Ministry of Defence was a respondent, and it stood separately from the resolution that came of that particular issue in that regard. And Mr. Justice Stevens, in his judgment, and over the luncheon adjournment, I'll get you the MS reference for this. In his judgment, Mr. Justice Stevens, in the Ryan case, recognised the fact that the Ministry of Defence was staying separate from that.
No, but the claim, I mean, this isn't, as it were, a sort of public inquiry. The claimant doesn't have to bring in everybody. The claimant only has to bring proceedings against one person who is responsible for the violation of her convention rights.
Yes, my Lord, and indeed, of course, that's what has happened here. There is an issue then in terms of the damages award, and that's the issue which, of course, the Court of Appeal has yet to speak on.
Well, it's an issue of contribution. I mean, if the respondent chooses to bring in other parties in order to have the award divided up, so be it, but provided she brings her claim against somebody who is responsible for the entire delay in respect to which she's claiming, it doesn't matter that other people might also have been responsible for it.
Yes, but I think, my Lord, it depends whether it can be said that that public authority that has been targeted in the judicial review can be held responsible for the entirety of the
Yes,
delay.
is it joint and several liability? Or
And thankfully, those are issues which respectfully I say we don't have to address here today. I strongly suspect, as I've indicated earlier, that at some stage in the future I'll be standing here in front of this court or in the other court addressing those issues. I strongly suspect.
But if you're right in that submission, then it puts a bar on any standardised compensation, because you could never say that one public authority was responsible for it. That leads to the thought whether, in order that there should be an effective remedy under Article 2, there isn't a further adjectival obligation on a public authority to be responsible for standardised compensation, but itself to work out who, among other public authorities, might bear the final burden, in order that, as I say, that the one claimant, the individual, the victim, has an effective remedy against somebody.
Yes, well, there may be occasions when that standardised type case or an inquest has not commenced. There may be, hypothetically, I don't want to be tied down to any particular case, there may be, hypothetically, circumstances where it would be clear that there's one public authority to blame. It might be, for example, that an extreme example, that the police have not at all fulfilled their Section 8 duty under the Coroner's Act to provide disclosure at all, and that has been the bar on it. Or
well, some of these delays have been fairly clearly attributable to one public authority. Failing to transmit the file.
Yes.
Resisting disclosure.
In any particular,
made.
At any particular time, that's yes. Right. I think the complication comes really that when one goes through time of these processes, there's rarely just one problem. Usually there are a panoply of problems. They might be interlinked and overlapping, and that's where the complication comes. It's very difficult to actually say it's one public authority will necessarily always be engaged.
But that really leads me to this point. If in the special situation of Northern Ireland, it's going to be very complicated for courts to work out which public authority bears which part or share of a standardised compensation scheme, that there might be an adjectival obligation within Article 2 that to have an effective remedy, the claimant ought to be able to say, there's one public authority, naturally the Department of Justice, and it's then its responsibility to sort it out between other candidate public authorities.
Well,
if as it's much more able to do than the victim.
Well, could I say this, my lady, in response to that? The argument has come close to that on occasions, in some cases below. It's never quite come home in that sense.
It's not an issue which is before us.
No, it's not, my lord, that's right. But
Well, in a sense, we do have possibly to think about that sort of issue, because that's a fairly important plank in the argument that you leave things to the end.
Well, it only relates to the issue of damages. And this is the point that, in common with Dr. McLean, I think it's important that I stress that there seems to be two world views about what the Court of Appeal has done, and there's no real middle ground between them. We say the Court of Appeal's decision does not prevent and does not operate to prevent any applicant bringing a judicial review, or indeed some other forms of action, challenging or addressing an alleged Article 2 delay. The issue is solely related to, once one moves past, for example, declaratory relief, to having to consider whether just satisfaction demands that there must be more than declaratory relief. In other words, for there to be just satisfaction, will it be necessary for damages to be awarded? And we think that that's a critical restriction or limitation in what the Court of Appeal was trying to do. So the Court of Appeal judgment does not, we respectfully say, operate as the fundamental, all-embracing bar that my learned friend Ms Quinlivan trays it as. Therefore, one moves into territory whereby the court, and as we know that this particular case, whatever way the order might be phrased, unfortunately, the fact is this case was brought, it was a live case, and it has been now considered. But subject to the original stay application, or stay order, the stay in effect only related to the issue of damages, whether damages were necessary. The issue as to whether there had been a breach of Article 2, it was never controversial. There was no issue taken, as I understand it, in respect to that. I should hasten to add, the Department of Justice was not a party to the case below in the High Court. It's our understanding of the situation, and I think by now, if we'd got that wrong, hopefully somebody would have corrected us on it.
Well, there are enough people in the room who could correct you.
One would think so, lady, yes, indeed. That the issue is not whether Article 2 is engaged, whether Article 2 has been breached. The issue in the Court of Appeal, in effect, by virtue of the PSNI's appeal, is what happens about damages. And the Court of Appeal's view on that, its world view on that was, well, for all the reasons which I'll perhaps come to after lunchtime, the Court of Appeal takes the view, well, that's actually a complicated issue that might involve a trailing through a lot of facts and addressing what each individual public authority did. And we'd be better placed to do that at the end of the inquest process. My Lord Reid has made the point, I think on a couple of occasions during the discourse with my learned friends earlier, that, in a sense, the Court of Appeal seems to be saying, well, we see your, I'm paraphrasing here obviously, we see your breach of Article 2, and we raise it with a telescope looking into the future, and there might be potential further Article 2 breach. And that, when one looks at it in that perspective, that does cause a sort of a jolting effect of, well, that doesn't sound overly attractive. Respectfully, we say the analysis should be looked at somewhat differently.
Well, I'm taking it from middle of paragraph.
Well, yes, I appreciate that more, but actually what the Court of Appeal, respectfully I say, is saying is, particularly the Lord Chief Justice, armed with the context which he is well aware of, is to know that this delay is not a drawbridge situation. It's not something that simply happened and has gone away and we're looking at it in the past, analysing it, as might be the case ordinarily in any other case. It was clearly operating in the context of an ongoing delay. And when the case was before the Court of Appeal, it was already patently obvious that there was going to have to be a further, because they had ordered it, there was going to have to be a further inquest process, and one simply didn't know what might arise in respect of it. Now, in actual fact, it turned out it went, in relative terms, in terms of Northern Ireland legacy inquests, it actually moved reasonably straightforwardly compared to some others. But the Court of Appeal was looking to the risks that these cases will not run as straight line issues, and there will be problems ahead. Perhaps on that note.
Yes, that seems a very appropriate note at which to pause. And we look forward to hearing from you further at 2 o'clock, Mr. Cole. Reports now, Jan.